Daryl, say hello to Doug Neckers. We're going to get started. My name is Greg Peterson. I am the president of the Robert H. Jackson Center, and I welcome one and all to the 5th Annual International Humanitarian Law Dialogs, entitled Widespread and Systematic Crimes Against Humanity in the Shadow of Modern International Criminal Law. And what's really amazing to me, and it's a real compliment to Chautauqua Institution and the various sponsors who have made this all possible, is the fact that we have in our midst today Daryl Mundis, the prosecutor for the Special Tribunal for Lebanon, Fatou Bensouda from the International Criminal Court, Serge Brammertz from the International Criminal Tribunal for the former Yugoslavia, Andrew Cayley from the Extraordinary Chambers in the Courts of Cambodia, David Crane from the Special Court for Sierra Leone, James Arguin from the International Criminal Tribunal for Rwanda, James Johnson from the Special Court for Sierra Leone, Robert Petit from the Extraordinary Chambers in the Courts of Cambodia, and our United States Ambassador at Large for War Crimes Issue, Stephen Rapp. All of them have made incredible efforts to be here today at Chautauqua to be part of this International Humanitarian Law Dialogues, and we appreciate all of your attention to this wonderful subject and their willingness to be part of something very big, of which we are filming, which, by the way, if you have your cell phone, of which I do, and which it is on, I will turn it off. Tom Becker would be so proud at this moment. But we're really honored to be at Chautauqua, and part of the wonder of having all the prosecutors here, because they do not get together. They do not have the opportunity to be together at a collegial moment. And by the way, if you look at some of the prosecutors and some of the participants, if they look a little sleepy this morning, it's only because their collegiality extended late into the night last night. And if you want to, I don't want to call them out, but I will in just a second when I introduce them, the individual who was the perpetrator of their late evening. But we are at Chautauqua. This is a wonderful location to have this, and to have this sort of the continuation of what's been a terrific nine-week season at Chautauqua. We're just honored to be here. And I'd like to call forward Geoff Follansbee. Geoff Follansbee is the Vice President of Chautauqua Institution and also the CEO and President of the Chautauqua Foundation and a fellow lawyer. Geoff?
Well, thanks, Greg, and welcome to all of you. We are thrilled to have you here once again. As Greg mentioned, we just concluded 65 days of the Chautauqua program, where we sought to work with our community to build a stronger democracy, really. That is what we think that Chautauqua Institution is all about. How do we bring together citizens from our country and indeed from all over the world to consider the issues of our time, and to do so in a way that builds our capability as communities and as a country to deal with, and in fact even to learn how to talk about difficult issues. And of course, that is very much what you're here to do over the course of these next 2 days. And Chautauqua Institution is very happy to partner with the Jackson Center, as we have since its beginning, and as leading centers within this community of Chautauqua County. It's always a great honor for us to work with the Jackson Center, as we do for this conference, but also throughout the year in so many different ways. So again, I welcome you. I hope that your days here are productive, that you enjoy yourselves. It sounds as if some of you already have been. that our facilities work well for you, and that you will continue to find this a place worthy of returning each late summer, but also at other times also. So thank you, and good luck over the course of these next few days.
Thank you, Jeff. An individual I need to just call out, and I want to make sure everybody recognizes him as the person who is the inspiration behind these international.
Thank you, Warren. My name is Lori Rabel, and I'm an English teacher at Hamburg High School, and I'm a teacher at the Summer Institute for Human Rights and Genocide Studies in Buffalo. We're very happy to be here today for the 4th year in a row, thanks to the generosity of Greg Peterson and David Crane, and all of the international prosecutors who have always welcomed us and so graciously given of their time year after year to talk to our students. You continue to inspire us, and we thank you for all of your hard work to defend human rights around the world. For those of you who don't know about the Summer Institute, we're a program for high school students. We get together for about 2 weeks in the summer every year, and we study the history of the Holocaust and more recent genocides, and also human rights violations and accomplishments over the past several decades. And we're so happy and inspired to always have about 35 students from area schools all over Western New York who spend that time in their summer to study this very important topic in hopes to be a part of the future, a future where we don't have to worry about issues like this, a more peaceful future, like Warren said. This year's Summer Institute focused on women's rights as human rights, and also on the importance of being an upstander rather than just a bystander. So with this in mind, some of our students wrote essays on these topics for the 3rd annual Impunity Watch Essay, and I'd like to thank David Crane again and Warren Pop for helping us create this contest for our students. It's a process that they enjoy being a part of. This year's winner, Carrie Mcphee, is a 2011 graduate of Hamburg High School, and she's going to go on to study at the University at Buffalo. She's studying political science and international affairs, and she's so dedicated to this cause that she's actually skipping her first day of classes to be here today. So we're really excited to be a part of this process and to watch all of the work that you do. I'm going to give it back to Warren for the presentation, and thank you again.
So the winning Impunity Watch Summer Institute Essay Contest by Carrie Mcphee was entitled A Moral Responsibility, and it truly captures how we can use our understanding of history to create a more hopeful tomorrow. Ms. Mcphee called on all of us to recognize that we cannot afford to sit by idly as bystanders to atrocities taking place, but must become upstanders, ready to make another's cause our own. She poignantly referred to individuals that protected orphans against the Nazi regime, fought arduously for women's rights, and those that paid a heavy price for fighting for civil rights in the United States. I'd like to call up a couple of members of my Impunity Watch staff to help me present these awards. Eric Sigmund, our managing editor of the news, and Christina Berger, our new special features editor for this year. Now, Carrie Mcphee, if you'd like to could step up and join us, please join me in welcoming and congratulating Carrie for her hard work. So I just also want to let everybody know that Carrie's essay is going to be published in Impunity Watch online. That'll be available in probably just about 2 weeks. And then it'll also be in print in our print publication this spring, which will also be cataloged in Library of Congress, so you'll have it all officially filed away. And it's also going to be published in a wonderful volume on these proceedings that's published by the American Society of International Law. So congratulations again, Carrie, and please join me one more time in congratulating Carrie Mcphee.
Move in a little bit more so you can, yeah. It's a dance.
Congratulations, Carrie. That's really a big honor, and we're just thrilled to be able to, at this conference, be able to make this special presentation. And speaking of presentations, to present our next speaker is, in fact, the perpetrator of the baggy eyes of some of the people last night, Michael Scharf. Michael Scharf is the head of the Cox Institute at Case Western School of Law. He is an incredible individual who's been really in the forefront of the studies of international criminal law, programming, writing, author, and now songwriter that we've learned last night. So without any further ado, to introduce our main speaker for this morning, Michael Scharf.
Thank you, Greg. And the baggy eyes, that's all Dave Crane's fault, because this summer when we were sailing in the Netherlands, he said, why don't you bring your guitar to the next International Law Dialogs? For those of you who didn't join in our sing-along, I've been asked to bring it downstairs to the main balcony, the veranda for tonight, so come and we'll all sing along. And who knew international prosecutors could sing like bluebirds, right? Well, it is my great pleasure to be able to introduce your first speaker of this event, a very close and long and dear friend who has an outstanding career in this field. In fact, I would say that you could characterize him as one of the fathers of the modern international criminal tribunals. And I'm speaking, of course, of David Scheffer. David has an endowed professorship at Northwestern University and is director of its Center for Human Rights Law. I first met David when I was in my last year as attorney advisor for United Nations Affairs at the State Department. And thankfully, there was a change of administrations, and coming in with the new people of the Clinton administration was this dynamic individual who was Madeleine Albright's legal advisor up in New York. And he had a desk on the fifth floor, sixth floor, a floor above mine. And I remember the very first day he arrived, I had been working for years toiling to try to convince my colleagues that the International Criminal Court and other international tribunals was in America's interests, to no avail. And so I had put this huge notebook together of propaganda in favor of the international juris mechanism. And I marched up to David's office, and I was one of, I think, his very first appointments when he arrived, and I plopped down in his chair and plunked down the two big black notebooks, and I said, David, before you do anything else, please, please read this. And who knew that this was going to be his life for the next 20 years? He immediately played a huge role in the creation of the Yugoslavia Tribunal, writing the interpretive statement that the Yugoslavia Tribunal later has cited in numerous opinions that Madeleine Albright gave. He then worked behind the scenes tirelessly to create the Rwanda Tribunal, the Special Court for Sierra Leone, the Cambodia Tribunal, and then headed the U.S. delegation at Rome to create the International Criminal Court. This, I'm sure, was one of his most difficult experiences because the government itself was conflicted. We didn't have a unified position. We weren't able to compromise. But years later, the seeds that he sowed in Rome came to fruition in Kampala. And again, he was there, this time as an NGO delegate, working behind the scenes. A couple of years before that, he had the idea and joined me in creating an experts meeting to try to come up with some compromise ideas that might make it possible for the International Criminal Court to adopt the crime of aggression. We held this experts meeting at Case Western Reserve. He chaired the meeting. It produced a report, and some of those elements made it into the final compromise. And so even through academia, through his writings, he has continued to play this huge role. And the most exciting thing I'm looking forward to is his memoir of his times as Ambassador at Large for War Crimes Issues will be coming out in December. It's called For All the Missing Souls, or just All the Missing Souls. This is what happens when you try to do it without notes. and it's coming out in Princeton University Press. Now, David, I have a little special thing for you, and I also have copies for the other prosecutors. One of the people that is missing from this group who was here from the beginning is, of course, our old friend and departed colleague, Henry King, who was one of the Nuremberg prosecutors. And several of the people who've come to these sessions over the years, and along with Greg, who gave us photos, have put together a book that has his last lectures. And the book is called Henry T. King, Jr., A Life Dedicated to International Justice. And I just want to read the back of the book and then present it to you, and then we'll listen to your speech. It says, and this will probably be written about you and by somebody in a couple of years, a couple of decades. Henry King, in his 9 decades on the planet, yeah, it was a couple of decades, 4 or 5. In his 9 decades on the planet, the late Henry T. King, Jr. served as a prosecutor at Nuremberg, legal advisor of the Marshall Plan, chief corporate international counsel for TRW, chairman of the American Bar Association's International Law Section, professor of law at Case Western Reserve University, delegate to the Rome Diplomatic Conference on the establishment of the International Criminal Court, and honorary consul of Canada. In his final work, Professor King shares insights about his life's extraordinary journey, the history of international accountability for war crimes, and his philosophy of peace through justice. The book includes a foreword by Professor King's son, best-selling novelist David King, as well as personal recollections about Professor King by prominent international prosecutors, government officials, and academic colleagues. So now, without further ado, I present David Scheffer.
Thank you, Michael, so much. You have built an outstanding international law program at Case Western University School of Law, one that we all admire and humbly acknowledge, far exceeds our own efforts. Michael's contributions and those of his students to the ongoing work of the War Crimes Tribunals brings great honor to Case Western University. Now, you preempted me a little bit, Michael, because my next sentence in this prepared speech was, I have a rather telling sentence about Michael in my forthcoming book, All the Missing Souls, describing the day in 1993 when Michael left me holding the bag on the International Criminal Court. I write, quote, one of the State Department's hard-working lawyers, Michael Scharf, summarily dumped a thick 3-ring binder of preparatory documents on my desk one day as he was leaving for a teaching career and wished me good luck, close quote. I remembered that moment when I saw Liam Neeson's recent film, Taken, where the Albanian kidnapper of his daughter signs off on the phone with Neeson, who is determined to track him down, with the words, good luck. Needless to say, that kidnapper met a gruesome end at the hands of a revengeful father. Michael, I can assure you I have nothing similar in mind for you. There are so many other distinguished participants in this room, and it is a great honor to be in your company today. All I can do is say thank you to David Crane, to Greg Peterson, and Geoff, for bringing us all together again in this beautiful setting very far from New York City. Despite the many current issues before the tribunals, including the duty to arrest indictees and the threshold for determining crimes against humanity, I want to examine what has been happening in U.S. federal courts over the last 2 years on the enforcement of the Alien Tort Statute and federal rulings at both the district court and court of appeals levels that draw upon and have a very direct bearing on the jurisprudence of the war crimes tribunals. And I know I have a very mixed audience. This is going to get a little heavy on the law at times, but bear with me because I want to address everyone in this room, and I will try to draw this out as best I can. If anyone in this room presumes that U.S. federal courts are somehow oblivious to tribunal jurisprudence, the tribunals being the Yugoslav and Rwanda War Crimes Tribunal, the Special Court for Sierra Leone, the Cambodia Tribunal, and the International Criminal Court. So if anyone in this room presumes that U.S. federal courts are somehow oblivious to that jurisprudence, or scoff, if these courts scoff at the Rome Statute of the International Criminal Court, you are seriously mistaken. There is much to learn from recent rulings in the United States because corporate responsibility for the commission of genocide, crimes against humanity, and war crimes is at the center of these cases, albeit for civil and not criminal penalties. The tribunal should know how U.S. courts are addressing the corporate liability issue. For someday, the existing personal jurisdiction of the International Criminal Court may well be invoked to reach corporate executives, just as the International Criminal Tribunal for Rwanda achieved that task in the media case. We all should consider whether the time also will come when either the International Criminal Court or some other newly conceived tribunal actually holds corporations or juridical persons accountable with civil or criminal penalties for commission of or complicity in atrocity crimes. After all, I need not remind you that leading Republican presidential candidate Mitt Romney recently opined on an Iowa bale of hay that, quote, corporations are people, close quote. Recall also that the Supreme Court last year ruled in the Citizens United case that corporations, for the purpose of the First Amendment free speech clause, are equal to human beings. If that is indeed the case, as our conservative brethren believe, then such so-called people should be capable of committing atrocity crimes and be held responsible for them, just as are natural persons. Now, I realize some of you, particularly in the Academy, know the Alien Tort Statute rulings well, but bear with me, because a lot has come down in recent months. A brief setup. The Alien Tort Statute is a 1789 law that is one sentence long. Quote, "The district courts shall have original jurisdiction in any civil action by an alien for a tort only, committed in violation of the law of nations or a treaty of the United States." Close quote. As the U.S. Supreme Court explained in its famous 2004 judgment on the Alien Tort Statute, Sosa v. Alvarez-Machain, quote, "The first Congress understood that the district courts would recognize private causes of action for certain torts in violation of the law of nations. Still, there are good reasons for a restrained conception of the discretion a federal court should exercise in considering a new cause of action of this kind." The Supreme Court continued, "Accordingly, we think courts should require any claim based on the present-day law of nations to rest on a norm of international character accepted by the civilized world and defined with a specificity comparable to the features of the 18th century paradigms we have recognized." Close quote. Those paradigms from the 18th century were three in number: offenses against ambassadors, violations of safe conduct, and individual actions arising out of prize captures and piracy. Now, the Alien Tort Statute is unique to the United States. No other nation has a law of precisely comparable content. In fact, it is a remarkable extension of U.S. jurisdiction to events and perpetrators overseas in order to uphold the most significant human rights norms of our times. And that is why it has proven so controversial both at home and abroad. The law was necessary at the time, in the late 18th century, to demonstrate the new nation's commitment to international law, and the protection of foreign diplomats and various interests on the high seas in particular. But it was very rarely enforced until 1980 with a path-breaking case, Filarga v. Pina-Irala, concerning a Paraguayan Inspector General of Police who kidnapped and tortured to death a 17-year-old Paraguayan boy. He was sued in U.S. courts by the boy's sister, who won the case with monetary damages awarded to compensate for those acts of torture. Thereafter, a significant number of alien tort statute cases were brought against individual violators of the law of nations. In the early 1990s, with the Unocal case in Burma, or concerning Burma, corporations began to be targeted for civil damages under the Alien Tort Statute. So both natural persons, like the thuggish torturer, and multinational corporations, including major oil companies and other extractive and manufacturing operations, became targets for civil actions, meaning monetary only damages, in U.S. federal courts. The results of these complaints have been mixed, with far more actions against natural persons succeeding and far fewer surviving against corporations, although the latter often have been short-circuited on political question or other jurisdictional grounds such as form, nonconvenience, or non-exhaustion of local remedies, or been settled prior to judgment to the benefit of the particular victims bringing the suit. But for 2 decades, from 1990 to 2009, the federal courts never questioned the applicability of the Alien Tort Statute to corporations as tortfeasors, and did not seriously undermine the most important form of corporate liability, complicity in the commission of the torts, with any challenge to what we call the knowledge standard for aiding and abetting. Now let me clarify what the courts also have stated. When we refer to torts in the Alien Tort Statute, that includes commission of atrocity crimes. I will not linger on the court's explanations for this, just trust me. But it's a fundamental point, because the courts have turned to the war crimes tribunals to understand precisely what torts or atrocity crimes actually fall within the subject matter jurisdiction of the Alien Tort Statute, and thus unleash this powerful weapon for civil damages against corporations. The Supreme Court in Sosa v. Alvarez-Machain in 2004 explicitly noted in describing the subject matter jurisdiction, namely the crimes that can be of concern to the Alien Tort Statute, quote, that the door is still ajar subject to vigilant doorkeeping and thus open to a narrow class of international norms today, close quote. The court set the bar very high, and federal courts since 2004 have applied that high bar to legitimize only the most serious violations of international law, almost always being in the realm of egregious violations of human rights such as torture or the related field that is the subject matter jurisdiction of the war crimes tribunals, namely the atrocity crimes of genocide, crimes against humanity, and war crimes. In fact, it would be difficult to identify an atrocity crime in which a corporation may be found to be either complicit or directly perpetrating that is also free of Alien Tort Statute liability. Certainly, federal courts would not ponder too long the ATS's applicability to the atrocity crimes. The statutes of the war crimes tribunals, as well as their respective jurisprudence, have established substantiality thresholds for charges of atrocity crimes. This means that once a particular crime is charged and prosecuted before any one of the war crimes tribunals, it almost certainly will enter the realm of Alien Tort Statute liability, including for corporations. The ICC, the International Criminal Court, has a long future ahead, and the determination of what level and character of criminal conduct falls within its jurisdiction will continue to evolve each year. A federal judge, 20 years from now, will have a rich body of jurisprudence built upon that already generated by the war crimes tribunals to ascertain what does or does not constitute an atrocity crime. He or she will be able to use this knowledge to establish the parameters of alien tort statute liability here in the United States. Thus, when presented with an alien tort statute claim, federal courts very often turn to the war crimes tribunals to understand whether the violation meets the high bar set by the tribunals for the crime itself. The federal courts also turn to the tribunals to understand how to determine the direct commission of the atrocity crimes or whether the individual or corporation has aided and abetted in the commission of the atrocity crime. When it comes to aiding and abetting, some recent federal rulings, greatly contested now, have abandoned the jurisprudence of the international tribunals for Yugoslavia and Rwanda and latched onto a serious misinterpretation of the Rome Statute of the International Criminal Court to replace the knowledge standard with an intent standard for aiding and abetting. Through it all, the many federal judgments and the copious briefings that accompany federal cases of this nature, the statutes and jurisprudence of the ad hoc tribunals and the International Criminal Court, as well as the Nuremberg judgments, take center stage in federal courts and indeed have become the primary sources of law for the federal courts. Before I get into some interesting details about all of this, I do find it fascinating that given the debate in political, academic, and judicial circles in the United States, stretching back about a decade or so now, about whether there should be any reference by federal judges in their opinions to international tribunal or foreign court judgments, or often even to customary international law that has not been internally codified yet as U.S. treaty law, in fact, the federal courts are bursting at the seams with full-scale reliance on the jurisprudence of the war crimes tribunals overseas to determine the proper interpretation and enforcement of U.S. federal law. If I were to deliver this speech before a Tea Party gathering here in New York, I suspect there would be such outrage I may not make it off the stage in good health. This paradox of American courts fully embracing tribunal jurisprudence to determine the fate of claims under federal law, while some political, academic, and judicial dialogue paints foreign and international rulings as somehow poisonous to our system, becomes particularly stark when some senior conservative judges on the federal bench warmly invoke the Rome Statute and then misinterpret it to establish both an intent standard, and I'll explain that, an intent standard for aiding and abetting, and the denial of corporate liability under the Alien Tort Statute altogether. As the U.S. chief negotiator for the Rome Statute of the International Criminal Court, I am astonished at seeing certain judges rush to endorse the Rome Statute as the guiding light for their rulings, while the far right's mantra for 2 decades has been to bury that treaty and all who subscribe to it. The Rome Statute has not become treaty law of the United States because Washington, though signing the treaty in 2000 in the Clinton administration, has never ratified it, and as you know, the world witnessed nearly a decade of the George W. Bush administration trying to undermine the court. God forbid that any right-thinking federal judge, particularly one of long-established conservative bearing, and there are many of them, would rely on the toxic Rome Statute for his or her reasoning on a federal statute, such as the Alien Tort Statute. But in fact, they do, shamelessly. Perhaps I can best describe this by relating my own personal journey in recent years through several Alien Tort Statute cases, and one Yugoslav tribunal case itself infected with one federal ruling, in which I filed amicus briefs, friend of the court briefs, to help clarify some issues for the judges. The story begins with the Presbyterian Church of Sudan versus Talisman Energy in 2009. This case concerned the Alien Tort Statute claims by the Presbyterian Church of Sudan and many non-Muslim Sudanese victims of human rights abuses who sued the Canadian oil company Talisman Energy in relation to its drilling operations in southern Sudan, which is now an independent nation. The plaintiffs alleged complicity by Talisman in genocide and ethnic cleansing, including massive civilian displacement, extrajudicial killing of civilians, torture, rape, and the burning down of villages, churches, and crops. While corporate liability per se was not challenged in that case, we'll come to that shortly, the critical issue was the standard for aiding and abetting liability. The Court of Appeals for the Second Circuit, New York City, and much, New York, Connecticut, etc., relied upon a novel interpretation of Article 25(3)(c) of the Rome Statute of the International Criminal Court to conclude that customary international law now requires that the aider and abettor essentially share the intent of the perpetrator of the atrocity crime, as opposed to the aider and abettor being held to a knowledge standard, namely possessing knowledge of or awareness of the perpetrator's commission of the atrocity crime and assisting or abetting such action, but not requiring the prosecutor to prove that the aider and abettor shares the perpetrator's specific intention. The Second Circuit's interpretation rests upon the use of the word purpose in Article 25(3)(c), and here I'm going to get a little technical, just bear with me, where this form of individual criminal liability under the Rome Statute is described as follows in the Rome Statute, quote, "For the purpose of facilitating the commission of such a crime, the individual or the entity, the individual aids, abets, or otherwise assists in its commission or in its attempted commission, including providing the means for its commission," close quote. The Second Circuit reads the word purpose to reflect a requirement of shared intent. And since, in its view, the Rome Statute, including that Article 25(3)(c) on aiding and abetting, since in its view it reflects customary international law, imagine that, it must mean that aiding and abetting liability requires demonstration of a shared intention with the perpetrator. Significantly, a knowledge standard for corporate aiding and abetting already had been confirmed by the U.S. Court of Appeals for the 11th Circuit, by 2 district courts in the U.S. Court of Appeals for the 9th Circuit, and by several district courts in the Second Circuit itself, including the Agent Orange product liability litigation in 2005 and the South Africa apartheid litigation in 2009, which were all about corporate liability. In the corporate realm and in Talisman, the case that I just talked about, it would be extremely difficult to prove corporate intent shared with the government of the country of investment to unleash government soldiers and militia to ethnically cleanse a swath of territory for oil exploration. It's very difficult to bring that proof that you're actually sharing the precise intent that the government has in sending its troops in. The Second Circuit Court of Appeals, or one looks to aiding and abetting theories of liability, which are far more prevalent for corporate operations. The Second Circuit Court of Appeals knocked the legs out of corporate liability with this interpretation of the Rome Statute and then required U.S. federal law to follow what I argued was a significant misinterpretation of the Rome Statute in my amicus brief. While the Second Circuit conveniently satisfies a conservative itch to minimize corporate liability for human rights violations, how odd that conservative jurists would resort to the Rome Statute to make the case for corporate freedom from liability. Now, in my amicus brief, filed alongside the plaintiff's efforts to seek a full ruling on this issue before all of the judges of the Second Circuit in New York City, I argued that the Rome Statute was never intended in its entirety to reflect customary international law. Articles 5, 6, 7, and 8 indeed were negotiated to record customary international law, namely the law we all have to follow, regarding the substantive crimes. If one applies the SOSA standard, that 2004 Supreme Court decision, to the Rome Statute, one can confidently identify the international crimes defined in the Rome Statute as representing the types of crimes that have universal character and are of a magnitude that falls within the jurisdictional scope of the Alien Tort Statute. But that sharp focus on customary international law for subject matter jurisdiction was never the aim of the negotiations regarding many other provisions of the Rome Statute. Now, while some of these other articles, including within general principles of law, could be viewed as expressions of customary international law, the aiding and abetting clause, Article 25(3)(c), is not one of them. That provision was negotiated not to codify customary international law, but to resolve the competing views of common and civil law experts on what both camps could live with as an agreed bargain on individual criminal responsibility. I do not recall a single discussion prior to or during the Rome negotiations where the text of the aiding and abetting clause as a mode of participation was being settled as a matter of customary international law. In earlier drafts, we stumbled repeatedly over what eventually was consolidated in Article 30 of the Rome Statute regarding the required mental element for all of the atrocity crimes. For the longest time, we could not agree between common law delegations and civil law delegations from Europe and Asia precisely how the mens rea language for aiding and abetting would be resolved. The preparatory committee draft in 1998, which was the initial working draft in Rome that summer, reflected this continued indecision by putting in brackets the words intent and then in brackets knowledge. In other words, we couldn't agree before Rome between intent and knowledge for aiding and abetting. It was only after we reached Rome in the summer of 1998 that negotiators finally arrived at compromise language. We knew that Article 30 of the Rome Statute, which deals with the required mental element to commit a crime, was our agreed formula on how both intent and knowledge would be described and applied as the mental element for all of the crimes unless specifically excluded. Article 32b had long been settled and easily captured the mens rea requirement for aiding and abetting, namely, quote, in relation to a consequence, that person means to cause that consequence or is aware that it will occur in the ordinary course of events, close quote, your basic aiding and abetting awareness. In the negotiations, we did not relegate aiding and abetting only to the first prong of means to cause that consequence or to the second prong of awareness. Of course, it is within the second prong of awareness or knowledge that aiding and abetting traditionally occurs and is validated under the Yugoslav and Rwanda tribunal jurisprudence. In any event, even if one were to argue successfully that the Rome Statute requires specific intent for an aider and abetter, sharing that intent with the actual perpetrator, that would be a highly peculiar feature of the Rome Statute. There is no evidence to seriously suggest that it represents international customary law. Since the judges of the International Criminal Court have not ruled on this issue yet, there is no guidance from them on how to interpret the Rome Statute. I argued in my amicus brief that the inquiry into what constitutes customary international law for aiding and abetting should be conducted elsewhere, namely in the jurisprudence of the international and mixed criminal tribunals and in scholarly textbooks of recent date, almost all of which confirm a knowledge standard for aiding and abetting. My footnotes in this amicus and subsequent amicus briefs and my co-authored article on this issue in the Berkeley Journal of International Law are replete with citations to tribunal jurisprudence upholding the knowledge standard. Talisman Energy, having avoided liability under the high bar for aiding and abetting set by the Second Circuit, once again prevailed when the Second Circuit denied the application for a rehearing en banc before all of the judges. In a last-ditch effort, the Sudanese victims filed a petition for writ of certiorari before the U.S. Supreme Court. I filed a new amicus brief at the Supreme Court in support of that petition. The Supreme Court denied the petition without comment in October 2010. Thus, the Second Circuit's novel interpretation of aiding and abetting liability, relying heavily on a misinterpretation of the Rome Statute, casting aside years of ad hoc tribunal jurisprudence, and knocking out most possibilities to hold corporations liable for atrocity crimes under the Alien Tort Statute, that still stands as federal law in the Second Circuit. It gets worse. Along comes the case Kiobel v. Royal Dutch Petroleum, again in the Second Circuit. This Alien Tort Statute case involves Nigerian residents who accuse Royal Dutch Petroleum Company and Shell Transport and Trading Company, acting through a Nigerian subsidiary, of aiding and abetting the Nigerian government in committing human rights violations, including killings, torture, forced exile, among other crimes. The plaintiffs allege that Royal Dutch Shell aided these violations by providing transportation to Nigerian forces, allowing their property to be used as staging grounds for attacks against civilians, and providing food and compensation to soldiers. The Second Circuit invoked the new Talisman intent standard for aiding and abetting to dismiss the claims against Royal Dutch Shell. But the Court of Appeals in Kyobo went much further, ruling for the first time in American jurisprudence that in defiance of 2 decades of Alien Tort Statute litigation against multinational corporations, that there is no corporate liability whatsoever under the Alien Tort Statute. The judge's source of law for this remarkable ruling, you guessed right, the Rome Statute of the International Criminal Court. 2 of the 3 judges of the Second Circuit Court of Appeals panel concluded that because the Rome Statute excluded juridical persons, corporations, from criminal prosecution for atrocity crimes before the International Criminal Court, then the negotiators must have concluded that any corporate liability of any character for such crimes must not exist under international law. The Circuit Court draws from its misinterpretation of a footnote, footnote 20 in the Sosa case of 2004, the requirement that corporate liability be specific, universal, and obligatory, that it be such a legal norm in order to hold Royal Dutch Petroleum or any other corporation liable under the Alien Tort Statute. That footnote in that Sosa case I won't read, but just trust me, it's been the center of so much litigation now, just this one little footnote. By so construing that footnote in the 2004 Supreme Court decision, the Second Circuit requires that the character of the tortfeasor, the corporation, must be firmly established as a matter of international law in order to attract liability. In other words, there must be international law that simply says, if you're a corporation, you can be liable for committing atrocity crimes. That must exist somewhere in international law before this federal court will actually allow it to be sued in U.S. courts. The Circuit then goes on to misinterpret the drafting history of the Rome Statute as revealing that the global community lacks a, quote, consensus among states concerning corporate liability for violations of customary international law, close quote. The 2 appeals court judges rely heavily on the Rome Statute to argue for the lack of corporate liability under international law, and thus they shield multinational corporations even from civil liability, even from monetary damages. But they do so by utterly misinterpreting both Supreme Court precedent, the Sosa decision, and then misinterpreting what we were up to in Rome when corporations were excluded from the personal jurisdiction of the ICC. Judge Laval, the 3rd judge in the Second Circuit judgment, scathingly demolishes the views of the majority judges Jacobs and Cabranes on corporate liability and finds ample authority and applies common sense reading to both U.S. and international law to solidly lock in corporate liability under the Alien Tort Statute. The Kyobo judgment has been appealed to the Supreme Court now in a petition for writ of certiorari. I filed an amicus brief at the Supreme Court explaining what happened to corporate liability in the Rome Statute talks in 1998. I wrote in that brief, quote, while it may be true that some countries allow certain civil penalties to arise within domestic criminal actions, the negotiators at Rome could not agree either on criminal liability for corporations or the punishment for convicting a corporation, including the formula for imposing civil penalties alongside mandatory criminal penalties. As a result, we decided to retain our narrow focus on criminal liability of individuals only under a statute designed to create an international criminal court, and left civil damages for natural and juridical persons out of the discussion and of the court's jurisdiction. If you bring a case before the International Criminal Court, it's not for civil damages, it's a criminal case. To read the failure to agree on and resulting omission of criminal liability for corporations under the Rome Statute as a, quote, express rejection of a norm of corporate liability in the context of human rights violations, close quote, as they did in Kiobel, is utterly incorrect. To then posit that one can infer under the Supreme Court's precedents that lack of criminal liability in the Rome Statute should dictate a lack of civil liability for corporations under the Alien Tort Statute is both a misunderstanding of the negotiation at Rome and an illogical reading of the Sosa v. Alvarez-Machain decision of 2004. Now, the Supreme Court will be considering the petition for writ of certiorari in Kiobel on September 26th in Washington. So we will all know very soon whether the High Court will be seized with this case. It is so important because there is now a decided circuit split in the United States federal courts on both the aiding and abetting liability standard and on corporate liability for atrocity crimes as they are framed under the Alien Tort Statute. Much has happened in recent months to sharpen that circuit split. In the Seventh Circuit, which includes Indiana and Illinois, a district court in Indianapolis held in Flomo v. Firestone Natural Rubber, a child labor case on Firestone rubber plantations in Liberia, that the Kiobel ruling in the Second Circuit was persuasive enough on corporate liability to scuttle the plaintiff's case in the Seventh Circuit. That case went on appeal to the Court of Appeals for the Seventh Circuit, sitting in Chicago, and I joined plaintiff's counsel during the oral hearing in early June. The oral arguments were simply remarkable. There sat before us the three most conservative judges of the Seventh Circuit, led by perhaps the most famous conservative Court of Appeals judge in America, Judge Richard Posner. Posner crucified Firestone's counsel on the issue of corporate liability, at one point telling the appellate litigator, who simply did not know much about Nuremberg or any international law arrived at since then, and who argued that Kiobel absolved Nestle of all responsibility. Posner barked at him, "Well, you lost me." The judgment, handed down relatively quickly on July 11th, completely upholds corporate liability under the Alien Tort Statute. But the judges dismissed the case against Firestone because, in their view, the plaintiffs had not substantiated that the child labor charges rose to the standards of violations of international law required by the Supreme Court. In other words, they were not shown to be atrocity crimes or even human rights violations of indisputable character under customary international law. And thus they fell outside the jurisdiction of the Alien Tort Statute. Nonetheless, this was a victory for corporate liability under the Alien Tort Statute, and thus created a split with the Second Circuit. Meanwhile, over in the Ninth Circuit, which includes California, a district court sitting in Sacramento had also followed Kiobel on both the aiding and abetting and corporate liability standards in dismissing the case of John Doe v. Nestle, USA, all that chocolate, which concerns Malian child slaves who were trafficked from Mali to Cote d'Ivoire and forced to work 12 to 14-hour days with no pay, little food or sleep, and frequent beatings, all for the corporate profits of Nestle, Archer Daniels Midland Company, and Cargill Cocoa. The case is now on appeal to the Court of Appeals of the Ninth Circuit, sitting in San Francisco, and I have filed an amicus brief contesting the district court's findings on both aiding and abetting and corporate law, findings which completely contradict other district courts in the Ninth Circuit and their findings on these issues. If the Ninth Circuit overturns the district court's ruling, the circuit split with the Second Circuit will be even more pronounced. We shall see. But the most significant development during the summer may have occurred in the District of Columbia Court of Appeals, Circuit Court of Appeals, which is at the same level as the Second and the Ninth Circuits, in the case of John Doe versus Exxon Mobil Corporation, a complaint under the Alien Tort Statute by 15 Indonesian villagers from the Aceh territory, alleging that Exxon's security forces committed murder, torture, sexual assault, battery, and false imprisonment, and various common law torts. They allege that Exxon took actions both in the United States and at its facility in the Aceh province that resulted in their injuries. In a judgment handed down on July 8th, The District of Columbia Circuit Court of Appeals rejected the entire Kiobel analysis of the Second Circuit on aiding and abetting and on corporate liability. And humbly, they cited my Talisman brief before the Supreme Court, and in 5 instances cited my Berkeley Journal of International Law article of earlier this year, all to clarify that the Rome Statute simply does not mean what the 2 Second Circuit appeals judges interpreted it to mean. The D.C. Circuit Court of Appeals also looks to War Crimes Tribunal jurisprudence to confirm the knowledge standard for aiding and abetting. In fact, here is what the federal judges said in the District of Columbia Circuit. Quote, "The court therefore looks to customary international law to determine the standard for assessing aiding and abetting liability, much as we did in addressing availability of aiding and abetting liability itself. Important sources are the international tribunals mandated by their charters to apply only customary international law. 2 such tribunals, the International Criminal Tribunals for the former Yugoslavia and Rwanda, are considered authoritative sources of customary international law under federal court precedents. They have declared the knowledge standard suffices under customary international law, period, close quote, end of story. The majority reversed the lower court's dismissal of the Alien Tort Statute's claims and remanded the combined cases to the district court. The majority opinion occupies 112 single-spaced printed pages, and in my humble view is a definitive treatment of both the aiding and abetting and corporate liability issues. Coming to the close. So we currently have at least the 7th, 11th, and D.C. Circuit Court of Appeals endorsing corporate liability under the Alien Tort Statute, and the 11th and D.C. Circuit Court of Appeals having ruled endorsing the knowledge standard for aiding and abetting. We await the judgment of the 9th Circuit Court of Appeals in San Francisco on both issues. The Second Circuit is the outlier. I suspect the Supreme Court will have to engage to resolve the gathering circuit split with the Second Circuit. And when it does, the briefing will be dense with tribunal jurisprudence and the interpretation of the Rome Statute of the International Criminal Court. We can expect the Supreme Court, when it renders its judgment, to rely on the War Crimes Tribunals and the Rome Statute for guidance. Of course, we may hear a different perspective from Justices Roberts, Alito, Scalia, and/or Thomas on whether the court dare look to international sources of this character to interpret the Alien Tort Statute, but I suspect Justice Kennedy will not hesitate to look towards The Hague and Arusha and Freetown on this one, and thus create a 5-judge majority to strengthen liability under the Alien Tort Statute. The most interesting element of this endgame at the Supreme Court for all of you, already at play in the Court of Appeals, doubtless will be American reliance on tribunal jurisprudence and statutory interpretation to confirm the character of federal law. Who would have predicted such reliance in the early 1990s, when the Alien Tort Statute began to be enforced against corporations and when the tribunal building era began? I cannot close, though, without noting that the appeals chamber of the Yugoslav Tribunal still could deeply influence the endgame for the Alien Tort Statute. There is a long-standing appeal before the appeals chamber by former General Odanic, sentenced to 15 years imprisonment on February 26, 2009 for crimes against humanity against Kosovar Albanians. He amended his appeal on the heels of the Talisman ruling, looking across the Atlantic, to argue that the mens rea requirement of aiding and abetting as established under customary international law has been defined properly by the Talisman judgment of the Second Circuit Court of Appeals in the good old United States of America to require the Yugoslav Tribunal to abandon its long-standing knowledge standard and embrace the intent standard, which of course would make it more difficult for the prosecutor to prove the case against the general. I filed an amicus brief with the appeals chamber, which has accepted it, challenging resort to Talisman and urging the appeals chamber to stay the course with the knowledge standard on aiding and abetting. If the appeals chamber of the Yugoslav Tribunal confirms the knowledge standard in its judgment on the Odanic appeal and does so by rejecting the misinterpretation of the Rome Statute by the Second Circuit, that will constitute powerful evidence for federal courts in the United States, demonstrating that the Second Circuit is wrong and that the Supreme Court should so conclude. And before that, the Ninth Circuit of Appeals, if the O'Donnell judgment is handed down prior to the Nestle judgment and any Supreme Court review. One can only hope that the Yugoslavia Tribunal Appeals Chamber benefits from the recent reasoning of the D.C. Circuit Court of Appeals on the knowledge standard for aiding and abetting in the Exxon case, as well as the 11th Circuit Court of Appeals, and I would remind you, many district court judges in the Second and Ninth Circuits. That kind of cross-fertilization, moving in both directions across the Atlantic, should facilitate well-reasoned opinions. Now, what happens if the United States, if the Supreme Court upholds the Second Circuit's judgment in Kiobel on corporate non-liability, including civil liability for atrocity crimes? In that event, we should follow the advice of the Second Circuit Court of Appeals. The majority invited American litigators to give much more serious consideration to civil actions against corporate officers and their often considerable personal assets for such individuals' critical roles in guiding corporate conduct leading to atrocity crimes and other human rights abuses. As they wrote, quote, "We note only that nothing in this opinion limits or forecloses suits under the Alien Tort Statute against the individual perpetrators of violations of customary international law, including the employees, managers, officers, and directors of a corporation, as well as anyone who purposely aids and abets a violation of customary international law," close quote. While bringing a civil action against a corporation is perhaps easier than against a chief executive of that company in terms of discovery and remedies, the Second Circuit opened the door wide for the Justice Academy to strategize ways in which to hold corporate executives accountable with civil remedies before federal courts. So this story is by no means over in the United States, either for corporate liability or CEO liability. Now, the prosecutor of the International Criminal Court, Louise Moreno Ocampo, got into some hot water back in 2004 when he told some reporters during an International Bar Association meeting in San Francisco that corporate officials who participate in atrocity crimes may be subject to prosecution by the court. The American business community pounced on him, as did federal judge Michael Chertoff, later become Secretary of Homeland Security under President George W. Bush, who criticized the dangerous overreach of the International Criminal Court. I trust the Office of the Prosecutor has not let a little criticism from the corporate guardians deflect it from worthy investigations. When the crime of aggression is activated, perhaps as early as 2017, before the International Criminal Court, such codification of the individual's criminality could have profound impact on corporate officers in terms of criminal prosecution. It also could expose corporations engaged in war-related enterprises, such as arms manufacturing and military contracting, to ATS liability. A ruling by the ICC invoking its jurisdiction over the crime of aggression could be easily interpreted by a federal court as establishing the basis for ATS liability over an atrocity crime, as similar rulings by the War Crimes Tribunal since 1995 have deeply influenced the range of torts or atrocity crimes that fall within the violation of law of nations established by the Alien Tort Statute. Therefore, while the tribunals have in the past and can in the future prosecute corporate executives for commission of atrocity crimes, I would propose that we give some thought to an expanded jurisdiction of the International Criminal Court to hold corporations responsible for civil remedies for complicity in or direct commission of atrocity crimes. What crippled us in Rome was the idea of holding corporations accountable under criminal law, as that concept simply is not uniformly held among national jurisdictions across the globe, in contrast to criminal liability for torts. In the United States, we have demonstrated that civil liability is a powerful weapon against corporate malfeasance in the realm of atrocity crimes. And if that principle survives the challenge by the Second Circuit Court of Appeals, perhaps the time will arrive for some serious thinking about how to hold corporations accountable with civil remedies before the International Criminal Court. After all, U.S. courts have long concluded that it is criminal conduct, the most egregious torts, that triggers so much of the Alien Tort Statute liability, including against corporations. That assessment would fit in logically with the mandate of the International Criminal Court. Thus, I am proposing more focused attention to the criminal prosecution of corporate executives which is already within the ICC's jurisdiction, and an amendment to the Rome Statute that authorizes civil remedies against multinational corporations found to be complicit in or directly engaged in the commission of atrocity crimes falling within the jurisdiction of the International Criminal Court. One can only imagine the complexities of such a proposal, but the fate of so many innocent victims of corporate liability, corporate complicity in atrocity crimes, requires that we finally consider the possibility of corporate accountability. Thank you very much.
Thank you, Mr. Ambassador, and for just that very insightful presentation. We're going to cause a break, but before we do, I just want to call out a few people. One, we have an individual here who was at the Nuremberg trial, and he was a part of the Communications Division. Don Ellison, if you'd please stand up. Don? Last night, at a special event, we had a chance to award the second annual Heinz Humanitarian Awards, which has been instituted by Josh Heinz, a very prominent lawyer in the Syracuse area, a member of the Syracuse University board, and just thrilled that he was able to do that. And I just want to call out a few folks who are here in the audience. The first award winner posthumously was Whitney Harris, a long-standing friend of the Robert H. Jackson Center and this particular event, and one of the founders of the International Humanitarian Law Dialogs. And Anna Harris, Whitney's widow and the recipient last year. Stand up, Whitney. Anna, if you will, stand up, please. Anna Harris. And last night we had two award winners. One was Bill Kaming. Bill Kaming was a Nuremberg prosecutor at the Ministries case, and the other was Ben Ferencz. Both of them were here last year, and Ben was recently had the privilege of closing a special case, which maybe Fatou Bensouda can talk about a little bit later, and also had the chance to spend some time with Angelina Jolie, if you happen to see that. So that's why he's not here. But his son was here is here and accepted the award, Don Ferencz, who himself is a prominent international lawyer. So if you see them during the break, please congratulate. And by the way, I see Josh over there. Josh, if you would please rise, because we want to thank you for all that you've meant to us and continue meeting. He's one of our board members, Josh Heinz. With that, we will adjourn, and we'll be back here for a report from the current prosecutors. Thank you. Yeah, well, we're going to try to convene about 10:40. We'll just a little 10 minutes late, but 10:40. Is there an extra for me for the center?